So, what are the problems though with land trusts? The problem with land trusts is they offer zero asset protection. That is, if you get sued as an individual and you have a beneficial interest in a land trust, I can go to the sheriff for a writ of execution on your beneficial interest. I can take it from you, is what I'm getting at with a land trust. So I can become the beneficiary of that trust and then gain control over that property. Another problem with land trusts is that they do not protect you from whatever happens inside of the trust. So if a tenant brings a claim for mold, for instance, they sue the trust. Through the process of discovery, I will find out you're a beneficiary. I will then amend my complaint to name you as an additional party to that lawsuit because your trust does not protect you. It's not an irrevocable trust. Okay? It's a revocable trust. In fact, it's a self-settled trust, so you cannot get that type of asset protection here in California as well. So, those are two main problems. Other problems with land trusts are in their execution, the way people put them together. One is they become dry. That is, you create a land trust and you never fund it, and then maybe you fund it 2 years down the road. There's a potential argument there that it was a dry trust and it extinguished on their own. However, even though that's a problem, there was an interesting case out of California not too long ago where somebody entered into a contract for sale with a distressed homeowner. They were buying it through a land trust, and the trust that they were purchasing it through in the purchase and sale agreement was not in existence at the time they entered into the contract. They said to be purchased in the name of the XYZ trust. They subsequently created the trust, and the court upheld the purchase and sale agreement, even though the trust wasn't around in existence at the time in which they entered into the contract. They said if you're doing it in anticipation of creating it, it's good. So I don't know how much California put into the dry trust argument, but it's just something to keep in mind. Passive, this is a big problem. Even though California law recognizes passive trust where the trustee has no power because they've done it through case law, I would not create a passive trust. That is, give your trustee some power over the trust at all times. Our default trust always gives the trustee powers to set rents. I do not adopt the Illinois-style land trust unless I have a client who is setting up a trust in Illinois, and even then, I like to err on the side of caution and say, just give them some power over the trust assets. So that's an issue. Merger. This is an issue that can kill this. Again, California doesn't follow this rule, but I would if I were you. Merger doctrine is as follows. If you create a trust where you're the grantor, you're the trustee, and you're the beneficiary, you can argue that, again, you have unanimity of title or of positions and title, therefore it reverts back to the grantor. So it's as if the trust transfer never took place. That can be a big problem for you, and here's where I'm going with that. Let's assume I'm here, I create this land trust, and I deed the property into the land trust. Clint is the grantor, trustee, and sole beneficiary of this trust. Now, I take my land trust and I drop it over here into this LLC for asset protection. I think everything's fine. And I'm moving around doing my real estate investing. 3 years later, I'm sued because this tenant brings a claim against the trust. Now, I argue through discovery that, hey, the trust is owned by an LLC. Your liability, or no, your recovery extends to the assets of the LLC and those of the trust, nothing else. The attorney on the other side might argue, ordinarily that is the case, counselor. However, we should apply the merger doctrine here because when that trust was created, we had the same person in all three positions. So there wasn't a position that was indistinguishable from the next. Therefore, title never transferred to that trust. So under law, you still own title to that real estate and you're the responsible party. So that is a problem that you could face. Now you could argue under California does not follow that rule. I would not do that. So here's how I would create your trust then. I would set it up so that if you're married, you could have husband and wife as the beneficiaries of the trust. Only one of them would be the trustee. That's okay, because now we have two beneficiaries, one trustee. They're different. I mean, some of them is the same, but there is a different party on that trust agreement. So I would do something like that. If you're just a single individual, then I would use an attorney or somebody you trust, and I'll explain that here in just a second, as your trustee. So you would not be the initial trustee of your own trust. I serve as a trustee on a number of different trusts for my clients. And it doesn't really complicate things until you're trying to refinance a property. Then we have to do some paperwork shuffling to assist with that. I think this is the best way to go. And when it comes to notifications, I may tell we're going to get into this in a second. I mean, you should never be corresponding with the county or with the banks when it comes to your land trust. You need to filter that through your attorney because you don't necessarily know exactly what they're asking. If you provide too much information, which happens a lot, then they come back to you and they say, oh, you know Prop 13 kicks in now because of what you did. And you go, no, I didn't know that. Well, it just got reassessed. So, how do you protect the integrity of your land trust? Trustee and beneficiary, not the same. Do not ever use a close friend as your trustee. This is a bad situation. When I've dealt with this client. He has a good friend. He utilizes this friend as a trustee on multiple land trusts that he's created in New York. Now, his buddy decided at some point in time that he was not subject to taxation in New York and quit paying his state taxes. New York, of course, agreed otherwise, and so they then filed a lien on every piece of property that this individual's name appeared on, either as the individual owner or as the trustee, because they assumed that because his name was on there as title, it said XYZ Trust, John Doe is trustee. They just said, yep, that's property he owns. That's his trust. Why did they make that? Because that's just the way they do things, blanket filing. You also run the problem if there's a judgment entered against your trustee and it's filed in the county where you may own property he's listed as a trustee on it, then that judgment will probably attach to that particular property possibly. You never know. So what I would do is keep him off of title. Not keep him off title. Do not use a friend as your trustee because of these inherent problems. In the situation with my client who utilizes Buddy, he had to hire an attorney and fight with the state to get those tax liens removed from each piece of property. The state took the position that there is maybe some collusion involved, of course. They figured that maybe they were trying to hide the property so this guy didn't have to pay property tax or pay the back taxes that were owed. So it's just a mess. That's why I say use an attorney, somebody that is licensed, professional, so you lessen the risk of that occurring. That's just it on that one. So treat your trust like a separate entity. All right, bank account. Yeah, you do if you have his question was, you still have the liability if your attorney has any risk of judgment against him. You do, but I think it's less because the attorneys have insurance that's going to kick in to help protect them. Most individuals, they're going to get a judgment entered against them and because they're going to default on it. It's the filter factor, yeah. And I'm going to show you a way to not even, I'm walking you through this as best practice, but there's a way around this as well, of course. I'm not going to hang you out there. So, treat your trust like a separate entity. This is important. Now, before break, somebody brought up, hey, Clint, we don't need to create a bank account for our trust because we have an LLC that has the bank account. Trust doesn't need one because it's just all handled by the beneficiary. That's old school. You're right, that would work. If you create an LLC in California, you create a land trust in California, and you have the land trust owned by the LLC. So here we go. We've got this land trust here. It's owned by this LLC right here. Then I would tell you create a bank account down here and just run everything through the LLC account. Because it's a beneficiary, we don't need to have a separate bank account set up for that trust. That would work. Make sure you also have your insurance. You name the trust as an insured under your policy. That's important as well. Make sure everybody's covered when you set it up. Change your rental agreements, of course. But the issue you run into is when this LLC here is not in California. Then you're going to need a bank account for that land trust. So that will be an exception to the general rule. Whenever I create a land trust for myself in any state besides California, I will set up the trust, the LLC, they're in the same state. I won't open up an account under the name of my trust. I have my LLC have the account, my tenants will pay the LLC. It doesn't matter to me, because at the end of the day, the LLC is the one at risk anyway. So you might be thinking, well, Clint, if the tenants sue, they're going to sue your LLC. They get there anyways. It doesn't matter. So one account is sufficient for me in those circumstances. But when you create a land trust in state X that's owned by an LLC in state Y, now you have a problem. Because how is it that the tenants in state X are paying the entity in state Y? Okay, the entity in state Y is not registered to do business in state X. So how can it collect rents on behalf of that rental property? So therein lies a problem. That's why if you're utilizing a trust in that scenario where the LLC is not registered in the same state where the property is located, then your land trust should have a bank account set up for it. So just open up a standard trust account with your bank.